Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This is episode 344 of Registry Matters. Larry, how are you tonight?
I'm doing awesome. It's nice and toasty here.
I bet it is quite toasty there. We're almost at the longest day of the year. It's got to be, I don't know, what is it, 150?
122.
Seriously?
No, 93.
Oh, I was like, damn, that's pretty toasty. Even for you guys, that's up there. You've lived there for 100 years. What's the highest temperature you've ever seen there?
I think 107 or 109, the highest it's ever gotten here. The altitude is high enough here that it doesn't get those blistering temperatures like they have in other places.
Like Death Valley or something?
Yeah.
I was in the desert when I was in the Army. I was at a National Training Center at NTC. I think that's what it's the long version is. Holy moly, it was hot there. I mean, it was hot. 115-ish, and you've got to wear all the Army gear. You've got Kevlar, you've got a helmet on, flak vest. Oh my God. Murder hot. We have a guest. We have Chance joining. I should call Chance a guest. He is joining us. Chance, how are you?
I am joining you. I'm good.
I mean, you are
good.
a guest.
So,
but you're like,
I'm a
you're
guest.
always here. Often here.
I'm here.
Hey, head over and make sure that you show some support by hitting like, subscribe. You can hit the button on YouTube where the thumbs up. You could subscribe. You could hit the notification bell. Leave a 5-star review. All these things would help the podcast. It would help us grow and help us reach new listeners, which is what we are always trying to do. And I think that'll be enough of that. And then I would expect that Larry will then tell us what we are going to do this evening.
Well, the great news, you've already laid it out, is Chance is with us this week, which means it's not just Mr. Doom and Gloom. Chance will have a California Corner segment later. And the big thing we're having is we're covering a case from the West Virginia Supreme Court of Appeals, which is their top court in the state. And it's actually good news for PFRs. The gentleman took his case to trial and was acquitted on all but one count. Then he appealed based on judicial misconduct and won. We have an article to cover, and I think that's going to wrap it up for this episode. I think that'll probably fill out an hour. You remember last week I was miserably off on how long I thought it would take. So this time...
You thought we were done in like 10 minutes. I was like, no, that's not happening that way. All right, well, today we're covering a significant decision from the Supreme Court of Appeals of West Virginia, which you've already said, and let me finish. West Virginia in State versus Eldridge. And like, I guess a state can call their Supreme Court whatever they want. They could call it the Supreme Court of the universe or something if they wanted to. They all seem to have weird, different names.
They do.
And what's the reason that you've put this case in here for discussion? I mean, FYP's airtime is incredibly valuable, as you were already aware.
I know. We actually charge about $300 for each 30-second spot that we run.
Well, man, we get that much money for advertising?
Actually, I would like to pursue an advertising route, but we just don't have quite the following yet that I don't think we can charge a lot for ads, but I'd love to go that direction, but I've lost my track. Where the hell were we?
Does this have any constitutional implications? That would be the question.
Well, the case is actually, my script is a reminder that judges have to play by the rules just like everyone else. And there are big constitutional implications here on this case that we're going to get into. And since we have an attorney who's practiced for 35 years, who celebrated 35 years of practice this week, and I'm sure he's seen some judicial misconduct through the years, he's going to be the color commentator jumping in from time to time to help polish up what I and AI created here.
You mean Chance is going to do like color commentary like Jimmy the Greek?
That's what it seems like to me.
Do you guys know that story?
Chancey the Greek.
Chancey the Greek. You might say something and we'll have to break for a commercial and you will never return.
Did I say Greek or geek? Okay, Greek.
I was hoping Greek. All right, anywho.
Chancey okay.
And even though it's a case involving a conviction, it has major implications for due process. Oh, we don't care about that. And fairness. Also, we don't care about that. Can we dive into the details, Larry?
No, we can. Chad Eldridge was accused of sexually abusing his stepdaughter, GY, and that's common that they use initials with minors between the ages of 12 and 17. The charges were very serious, 17 counts, including sexual assault, sexual abuse by guardian, and incest. And so he was facing some serious time had he been convicted. I mean, he's got testicles of steel to go to trial on 17 counts in West Virginia. That would have been 300 or 400 years in prison if he'd been convicted.
So that's a lot, though. What happened at trial then?
Well, the jury amazingly acquitted him on 16 of the 17 counts. The only conviction was for a second-degree sexual assault involving oral sex. It was tied to an incident where he allegedly forced GY to perform oral sex.
So the jury clearly had doubts in all this?
They did. They had serious doubts. If you acquit on 16, and we can get a chance in here on this, if you've got a 17 count indictment and the jury acquits on 16 of those counts, I would say they had serious doubts, but the judge got involved in the way that the Supreme Court later ruled was improper. And that's what led to the reversal. But Chance, in your years, have you seen anything like this?
No, I haven't quite seen it this heavy. But acquitted on 16 of 17 counts is a big deal. Is a very big deal, and probably would cause that to just lay where it is. Who'd want to retry that?
Let me ask you the question this way, though. Doesn't the prosecutor find everything possible that could be remotely tried and layer those on there for them to ultimately just have one thing that'll stick?
Is that for me or Chance?
Either.
Well, my experience is much more limited, but prosecutors do creatively try to find things that might stick. And I have sat on a grand jury and I got to witness for 3 months what prosecutors do. But they claim that they're only following the evidence, but it's my opinion, having never been a prosecutor, that they're sitting around looking for something that they can make fit into a square hole, a round peg fit into a square hole so they can stack charges. Chance, would you agree with that? Do prosecutors look for something that just might be able to be squeezed into a square hole?
A whole bunch. That's why there's a whole lot of prosecutor misconduct. Yeah, they do that routinely. Yes.
So who was this witness the judge questioned?
The witness was R.E., which was the alleged victim's mother, and the accused, Mr. Eldridge's ex-wife. She testified that her daughter had previously made false accusations against Eldridge and recanted them. She also claimed that the latest accusations came after she told GY that she couldn't move in with her boyfriend.
Oh, so her testimony supported the defense?
Yes. I mean, this is the most bizarre thing I've ever seen in my 184 years. You're facing 17 counts, and you call the mother of the complaining witness as a defense witness? Again, Chance, have you ever seen anything like this? She provided alternative explanations and cast doubt on the timing and motives behind the allegations.
Yes, I have seen that.
You have?
I have. Yeah, I mean, when you make sure you know what people are going to say before they say it. That's the number one rule. And apparently, the defense had some cards they weren't showing.
What do you mean by they had cards that they weren't showing in terms of that? Let's say hypothetically, we did a witness interview with the alleged victim. Are we obligated to share the fruits of all that with the prosecution, or are we not?
If it's rebuttal, no.
Okay, all right. So in rebuttal, because I thought I remembered that we had to be somewhat forthcoming with what we unearthed in our investigations. Okay.
But what does all that mean that the judge didn't like her testimony?
Well, during cross-examination, the state tried to suggest bias because she funded Eldridge's the accused jail account using her sister's credit card, which would signify that wasn't on the up and up. But when the prosecutor didn't go far enough to suit the judge stepped in and asked her point blank if she had pending fraud charges.
Is that allowed though?
I don't think it is under our rules here, but more importantly, it looks like in West Virginia, Rule 609 only permits using convictions to impeach witness credibility. Pending charges are not admissible, and that's on page 10 of the opinion. And the judge violated that rule, and more importantly, he stepped outside the bounds of neutrality. And again, Chance, expand on that. What all did the judge do that he ought not have done?
Well, I mean, you can't be a second chair prosecutor. Let's put it that way. And assessing credibility is crucial because a witness's testimony can significantly impact a case's outcome. So a judge has to remain neutral and not take the second seat and prosecute the case when he thinks or she thinks the prosecutor's not doing their job.
So is all of that allowed though?
No, Rule 609 only permits using convictions to impeach witness credibility. Now, a conviction is fair game because that's public record, but you're presumed innocent. But pending charges are not admissible, and that's referred to on page 10. And the judge violated that rule, and more importantly, he stepped beyond the bounds of neutrality because Chance pointed out the judicial system works on impartial judges. They're supposed to be fair and even-handed, and this judge had an agenda. He wanted that information before the jury, and that was not his role.
Because they're just supposed to like sit back and they're a referee. They're not they're not putting air in the football or taking it out depending on who's on the field, right?
That is correct. Now, I believe within our rules here, Chance may have similar rules to cite to in California, a judge can seek to clarify an answer that's misleading
Sure.
or not clear to the that a witness has given. Is that consistent with rules in California?
Yeah, pretty consistent. Well, but in California, we have a wider latitude when it comes to impeaching credibility. But, the federal rules here seem, constricted. And obviously, the rule precluded what he did. And he wanted the jury to know that she had something pending that hadn't been adjudicated yet, which is, not fair.
What's the difference then between Rule 608 and 609? I'm sure everyone is completely familiar with what those two things mean.
Well, I'm sure they are.
They're standard across the states, aren't they?
No, not exactly. Rule 608 allows you to ask about specific acts if they relate to the truthfulness, but they can't introduce outside evidence like charges or arrest records. Rule 609, on the other hand, allows prior convictions under certain conditions to be brought in for credibility purposes, but only convictions. And again, this was not a conviction. But the judge wanted to smear this witness because he didn't like where it was going.
And
yeah, see that, Andy, is 608 just prevents smearing with allegations, and nuances, but 609 says, look, if it's adjudicated and it's there, it's a conviction, it's fair game, depending on what it is.
So what we're saying here is that the judge broke the rules?
Pretty much. He asked about charges, not convictions, and by bringing that in himself, he gave the impression that the witness was dishonest, something the jury was supposed to decide, as Chance said. Truthfulness and credibility is for the fact finder, in this case, the jury.
Can then the prosecution claim that the charges showed bias?
That was actually their angle. They argued that since RE had committed fraud to support Eldridge, it showed bias. But they already had her testimony about using the card. They didn't need to mention the pending charges. And the court said that was a step too far, and that's cited to on pages 12 all the way through 16. They did quite a story, explanation of that.
And then the bias was already shown by her actions, right?
Yes. And courts have consistently ruled that you can use witness actions to show bias, but not on proving accusations. That's just too prejudicial.
You did mention something unusual earlier. Oh boy, vibrators?
Yes, on this family program, that word comes up. RE testified that she gave the minor daughter 2 of those devices when she was about 15 or 16, so she could explore her own sexuality and without the help of boys. Which, I mean, there is some logic in that. Would you agree?
I have a story I could share, but I'll have to wait till afterwards about the equivalent on the male side, so to speak. But anyway, That's certainly unorthodox.
It is, but the problem isn't what she did, it's what the judge did. He asked multiple judgmental questions. Did you show her how to use them? What did she think? Was it a good idea? Did she talk about it with Eldridge? That was not clarifying an answer. That was eliciting answers to questions that were not asked. Chance, do you agree?
I agree. Yep.
And
That was a way of just throwing slime on her.
and this sounds like the judge was maybe expressing a little bit of his own personal bias and moral outrage that this would be going on.
That's how the Supreme Court saw it. Judges, again, must remain impartial, especially when credibility is at issue. This wasn't clarification, which judges are allowed to do. It was condemnation, and it broke Rule 614B.
So the judge, again, looking like he was siding with the prosecution and against the defense, which I don't think judges are supposed to do. They're supposed to be just straight up like the guys with the stripes that are on the field saying this was a foul, this was fair play, but they're supposed to just be fair in the middle.
That's correct. And when a judge appears partial, especially in a close case, it can certainly sway jurors. And in this case, it possibly did.
And to that, then, what did the West Virginia Supreme Court say about that?
They said the judge's actions weren't just wrong, they were prejudicial. The trial was credibility based. It was G. Wyde's word against Eldridge and the defense witness. The mother was key, and the judge undermined her. That influenced the one conviction. And so, the judge sunk the case. It might have gotten the conviction anyway, might not have, but the judge sunk the case.
Was the jury deadlocked up to that point?
Yes, and that suggests they were struggling. Then they convicted him on the one charge from a single incident and acquitted on all the other charges, died the same event. The court said that suggested it was a compromise verdict.
Could you explain that? What does that even mean?
That's kind of like cutting the baby in half. You got 12 people sitting there, and they all want to go home because jury service pays very little, if anything. And
yes,
they're giving up their day jobs and stuff, and they want to get out of there. And so you got to hold out. If you can reach a compromise verdict, that happens. I bet Chance could expand on compromise verdicts because in 35 years, you've probably seen a few compromise verdicts where the evidence just didn't support the verdict.
Yeah. I would say so, except that you don't really understand what's going on in the state, at least what's going on. But essentially, yeah, stuff like that goes on. Not very fair, is it?
No, it doesn't sound like it. What's next for Eldridge then?
Well, at the moment, his conviction is gone and the case is remanded for a possible new trial. The state can retry him, but they'll have to avoid these errors, and they can only retry him on that one count because jeopardy has attached to those acquitted charges. There's no way they can bring those back. Is there a chance?
No. If you're acquitted, you're acquitted. But who would want to go on just that one count after that? That's massive, which is what I was referring to before.
The takeaway for me is, judge, even in serious cases, the rules must be followed, and the judge didn't follow the rules.
Is this actually a resounding victory for due process?
It is. If we don't decide guilt by mob sentiment or judicial opinion, everyone is supposed to get a fair trial. And Mr. Eldridge didn't get a fair trial. But amazingly, I just can't imagine him going to trial in rural West Virginia on 17 counts and having the courage to call. If you'd have brought that case to me, I'd have said, "You're going to call the mother? What kind of wacky weed have you been smoking?"
But don't we almost all the time talk about the prosecutor's not going to lay down? He's going to figure out some other angle to go after this and drum up different charges, even though because he knows he's got the one?
Well, I agree, but the courage of getting to that position. Now, we don't know what offer was made in terms of a settlement, in terms of a plea offer. We don't know that. That was not discussed in the case. But whatever the plea offer was, they wouldn't have asked him to plead straight up and down to all 17 counts. So he would have been restricting and reducing his access by entertaining a plea offer. But if they offered him like 90 years in prison, well, you're going to die in prison anyway. You might as well go to trial in that case. But if they offered him something where he could actually see the light of day again, it's just a very, very courageous thing to do, to go to trial on this when you're facing hundreds of years in prison.
Interesting.
Agreed.
And what kind of timeline does that then take? If he's essentially, like, where in the process is he? Is he past indictment? Do they have to do it all again? Could he like flee the country if he wanted to? What are his options?
Well, got to wait for the remand to be sent down to the trial court. And this is not something that's highly automated. This is going to be something where ultimately the chief prosecuting officer in that district is going to make a decision what they want to do. And there are going to be many factors that go into that decision, like how profile they've made this case. And sometimes their own stupidity puts them in a jam where they have to do the case again because they made such a production out of it. And I don't know that they did or didn't, but if they did, they've boxed themselves into a corner, because if this victim got all sorts of airtime on TV and radio and newspaper about how this man was going to die in prison, and all of a sudden all convictions have been set aside on the remand order, he's going to get a certain amount of time. It may work different in West Virginia, but he's not going to walk out the gate of prison immediately. They're going to give the prosecution some period of time to decide what to do. And but it's not going to be a definite period of time. Chance, how much time will they get to decide, in your experience, of what they're going to do with this case? Because they've got to first figure out if the witness is available, willing to go through it again, what evidence they have left that can be brought to bear at a trial. There's a lot of things going into this, and how will public opinion play? Because I've got to consider this as an elected official. If I get another acquittal on this one count, after having been turned back on all 17 counts, I don't look particularly competent. I would be tempted to want to just let this case go away, but I don't know that they can, because I don't know what the lay of the land is in terms of pretrial publicity.
Right. We probably don't know enough. But you're right about that. They have to consider all these things. They're a political entity, and this is bad publicity, real bad publicity, and it really goes to their own credibility. So it could take months of meetings and thinking and making a determination, or it can simply be a quick no-brainer. We're not doing this again. Depending on what the facts are, and we're not aware of those right now. We don't know everything, but if you're asking me if it could take a while, yeah, it could take months.
Well, and he just sits there stewing while waiting.
No, if a remand comes down, the trial judge is going to give the prosecution an amount of time, and I don't know what that amount of time is going to be, is to make a decision. And they're going to set conditions of release if the prosecution is going to go forward. How much time they will give them to make those decisions, I don't know. But he won't just sit there and rot forever. But he could easily sit there 30 to 60 days waiting for something to happen.
Okay,
right.
All right. But
right.
I mean, we talk about the worst day in the prison system in New Mexico, and just by one day you could end up on a gurney. But 30 to 60 days is not the end of the universe, but certainly not where I would want to spend even one day.
Right. I mean, when you think about it, and we're moving on to a speedy trial, that's universal.
Okay.
So it's not like he's going to have to wait there forever.
Okay. All right. That kicks in to help him then. One of those, that's a constitutional right?
That is.
Okay. Well, very good. Well, thank you, gentlemen, for breaking all of that down and all the commentary. Wait, you are Chance the Greek? That's what Chancey the Greek. That's what you are.
Chancey the Greek. Yeah.
All right.
Right.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say F YP.
Let's move over to, this will be California Corner, and it's understanding Serna motions. And that's not SORNA, that's Serna motions and the right to a speedy trial. Is that what this is?
That is correct.
Oh my God. Okay, so we're diving into Serna motions and the constitutional right to a speedy trial. And as always, we have the insightful, occasionally witty, and very brilliant attorney Chance Oberstein, who specializes in criminal defense in California.
All right. Thank you for that intro. I'm thrilled to be here, and occasionally witty.
Yes.
I'll take that as a challenge. And I'll see if I can keep you entertained while we talk about the law.
Challenge accepted. All right, so Chance, let's start with the basics. What in the world, I've never heard of this before, is a Serna motion, and why would anyone give two flips about it?
Okay, great question. Okay, Serna motion is like the legal equivalent of calling out someone for ghosting you. It's a tool defendants use in California, okay, and it's a tool defendants in California can use to request the dismissal of criminal charges when the prosecution has taken way too long to bring the case to trial, like we were just talking about. It's based on the Sixth Amendment right to a speedy trial and is basically the Constitution's way of saying, don't leave people hanging. And in California, this right is backed up by Penal Code Section 686 sub 1.
And so it's like the legal system's version is you had one job. Got it. But what counts as too long? Are we talking weeks, hours, months, years? And in the case of Larry, we're talking centuries?
Oh, we're definitely talking years, and this is a different type of thing. The landmark case is Serna versus Superior Court. It's a 1985 case, and that set the standard. Delays exceeding 1 year for misdemeanors or 3 years for felonies are presumed unreasonable. At that point, the burden shifts to the prosecution to explain themselves. If they can't justify the delay, the court can dismiss the case faster than you can say statutory violation.
That's a pretty big deal, though. So what happens if the prosecution tries to pull a oops, we forgot card?
Well, Andy, the courts don't take kindly to the oops defense. In Doggett versus the United States, which is a 1992 case, the U.S. Supreme Court made it clear that government negligence, and we're talking government negligence, like losing track of a case or forgetting to file charges, is not a valid excuse for delay. If the government drops the ball, the defendant's speedy trial rights are violated, plain and simple.
From that, it sounds like the government needs to get a better calendar app. But what if the delay isn't just negligence? Are there factors that the court could look at? I mean, we could have an attorney who shows up to court late and just like, whoops, traffic.
Well, absolutely. That's where Barker v. Wingo, it's a 1970 case, comes in. This case gave us the Barker balancing test, which sounds kind of odd, but it sounds fancy, but it's just really a checklist. The court looks at 4 factors. Number 1, the length of delay. Number 2, the reasons for the delay. Number 3, whether the defendant asserted their right to a speedy trial, or how the delay harmed the defendant. It's like a legal pros and cons list, but with much more higher stakes.
And if the prosecution drags their feet, the defendant can basically say, well, that's unfair, and here's why. Can we bring some kind of life with an example? Got any juicy cases that you could cite for us?
Well, I've got a good one that I can use for an example. Picture this. Orange County, 2019. A defendant is accused of vehicular vandalism on September 16th, 2019. Fast forward then to January 15th, 2024, more than 3 years later, and the prosecution finally issues an arrest warrant. The defendant has been living at the same address the whole time, probably wondering if the charges were ever going to show up. His attorney files a Serna motion arguing that the delay violated his speedy trial rights under Serna Superior Court and Doggett. The court agreed, dismissed the case, and the defendant walked away free.
Interesting. 3 years, though. That's not just a delay. That's like a full-on, that's a Larry nap even. And what kind of harm can these delays cause to a defendant's case?
Well, that's the point. These delays can be devastating. Witnesses may forget key details, physical evidence can deteriorate, and important documents might disappear into the abyss. So imagine trying to track down a witness 3 years later. They might not even remember what they had for breakfast yesterday, let alone the details of a crime. In the Orange County case, the defense argued that fading memories and lost evidence made it impossible to mount a fair defense. And these factors are critical in proving prejudice caused by the delay.
It does sound like a bit of a legal nightmare. If someone thinks their case has been delayed unreasonably, what's their first move?
Well, step one, and probably the most important step, is call an experienced criminal defense attorney. I mean, if it's been some time and now it's popping up and, it's unexpected and it's been a while, call somebody who can help you, really help you, and that's an experienced criminal defense attorney. They'll review the timeline of your case and determine if a Serna motion is appropriate. Filing the motion involves documenting key dates, like when the alleged offense occurred, when the charges were filed, when the defendant was informed, and attaching evidence to show that the delay hurt your defense. Then the motion is submitted under Penal Code 686-1, and the court schedules a hearing.
All right. And what about other jurisdictions in California? Are they all the same when it comes to filing this kind of motion?
Well, they're pretty much all the same with some minor variations, but let's take Orange County, for example. Orange County has its own flavor of bureaucracy. You need to serve the prosecutor with all the necessary documents and set the motion hearing for several weeks in advance. That gives everybody time to review the claims. As for other jurisdictions, an experienced attorney will know how to navigate these local rules without breaking a sweat or filing or missing a filing deadline.
Well, before we wrap this marvelous episode up, let's talk about bad lawyers, because I think there are a few that exist in my experience. What if someone feels their previous attorney dropped the ball on addressing delay issues?
Yeah, that's a problem. But if it is a delay issue, of course that's what you're going to the attorney for. If they miss it, or you feel that they haven't really examined it properly, no problem. If your attorney didn't address the delay issues, don't panic. You can always seek a second opinion. A new attorney can review your case records and police reports to identify missed opportunities. Sometimes a fresh set of eyes can uncover grounds for dismissal that your previous attorney overlooked or just didn't even know about. It's like getting a second opinion on a bad haircut, but way more important.
Well, we could have a whole episode here on second opinions, because I've not found very many attorneys that want to give a second opinion. But they say, "Are you represented?" Oh, well, then you need to be asking your attorney. I said, "Well, I go to the doctor and I don't like the opinion, and the doctor tells me, feel free to get a second opinion." I go to an attorney and I want a second opinion, and you say, "Oh, well, I can't break the rules of professional conduct. I can't give you a second opinion." And I've always rejected that, but they insist that there's some rule that I can't find anywhere in the book that says you can't give a second opinion. But anyway, that's an episode. So Andy put that on a list of things about to make a segment on second opinions, because I can't find attorneys that like giving them. But speaking of second opinions, what are some signs that the delay might actually work in the defendant's favor?
Okay, that's a great question. Sometimes delays can actually help the defense. For example, if the prosecution's case relies heavily on witness testimony, a long delay might weaken their case because witnesses forget details or become unavailable. Similarly, if physical evidence deteriorates or is lost, it can make it harder for the prosecution to prove their case. So while delays are usually bad for defendants, they can occasionally work in their favor. And if you have a savvy attorney who knows how to leverage them, voila.
Well, that's been a bone of contention in the years I've been in this business, is having that discussion with clients. I tell them that the apparatus that's coming against you has more kinks usually than ours does that can break down. And so if you've got a case that's contingent upon multiple witnesses, there's a lot more chances of a bus running over one of those witnesses that's critical, or them having an aneurysm, or them having a stroke, or them getting sent to Baghdad to serve in the army or something or other. There's all these things that can happen. And with you, that's going to work to your advantage if something makes that case weak, because remember, we have a confrontation clause. They can't just look at the police report and say, well, the officer is dead that investigated this, but for the report says this. I mean, and I'm going to get to the script in a minute, but what's the answer from a competent attorney when they try to introduce a police report without setting any foundation, or for trying to justify why the
Well,
report is going to, how does that work?
Well, there's a total lack of foundation.
So
That's, I mean, is it relevant? Is there any foundation? I mean, is this, there's levels of hearsay. There's so many different variables there, but it's trial by affidavit never works. And that's good, because our system is made to do much more than that. And it works, and it doesn't work by affidavit. That's something everybody like to do. Every prosecutor would love to do, but that's just not how our system works.
It's contingent upon confrontation, and that's something we need to protect. But the silver lining is something that most people don't think about: delays that can actually work to your benefit. It can actually work for your benefit, particularly if you're in custody. If I've got a client that's been in custody for a year and a half and they're scared to death to go to state prison, and I couldn't get conditions of release approved, and they've got a couple of years in custody, no prior record, even if it's a serious charge, I can say, well, Madam Prosecutor, this person has already served all the time that they're likely to get on a first offense. Let's go ahead and do credit time served and probation. That worked to your benefit. You never did have to go to the big house, even though you did have the conviction. So, but thanks for joining us today on this segment and shedding light on the Serna motions and the right to a speedy trial.
My pleasure. My pleasure. It's been fun.
Well, you put this thing in here, and it's from CPR. So that's cardiopulmonary resuscitation.org. Do you think that's what it is?
I'm pretty sure that's not what it is.
Okay. Well, this is some good news, but this is from Colorado Public Radio. God, this has got to be some lefty bleeding heart garbage, right? And it says, in recent years, incarcerated people have been denied visitation rights for breaking a prison rule. Legislation newly signed into law that would fix that. What is this all about?
Well, the law, which started out as House Bill 25-1013, introduced by State Representatives Rebecca English and Jennifer Bacon, establishes social visitation as a right for a person confined in a correctional facility. A right. Listen very carefully. That's powerful.
Wow.
It takes away prison staffers' ability to use denial of visitation. The Department of Corrections may adopt rules to govern administration of social visitation, but shall not restrict social visitation beyond what is necessary for routine facility operations or for the safety of the facility and public, the text states of the legislation.
This sounds to me like legislative interference with prison management. Shouldn't the warden be able to do what they want to do? Don't prison administrators know best?
I'm not so sure that they do. I'm not so sure that they do, because I think that people have, in administrative roles, they have many competing things going on in their head: the desire to administer justice, effectuate punishment that the court didn't hand down. And so there's so many things wrong with just leaving it up to prison administrators. But the article states those visits could get snatched away. The Colorado Department of Corrections website's Visit an Incarcerated Individual tab lists rules around visits, and breaking any rules in seemingly any area, possessing drugs, refusal to work, not behaving properly when receiving a visit, could be sanctioned by taking away an inmate's right to get visits. Even misconduct during a visit, where minimal physical contact is allowed, could result in visits being taken away. So I would suggest that this probably means that you might be allowed to hold hands, but you can't kiss. And if you sneak a kiss, you might lose your rights to visit. That's what I'm guessing.
All right. Well, I guess that's kind of to be expected. But what about major violations, which I assume means like bringing in contraband, for example?
Well, major visiting violations that jeopardize the security of the facility may result in permanent suspension of visiting privileges, the website states. Also adding that prisoners in the past could have their rights denied permanently for 3 drug-related offenses. And a prisoner with limitations on their visitation who transfers from one lockup to another would have the same restrictions from the first facility following the next one. That kind of makes sense. That part of if you've been placed on legitimate restrictions, you wouldn't escape them by magically going to another prison, I wouldn't think.
How do you think that such legislative proposals pass? Is Colorado the new bastion for liberal lefties? Damn communists?
Maybe it is. It had a short and quick trek through the legislature. It was introduced in January. It passed the Senate on May 2nd on a 22-12 vote, after having passed the House about a month before on March 26th with a vote of 44-21. For the most part, legislators voted along party lines, with all but one Republican in opposition. Amazingly, amazingly, the family that espouses family values and how important it is to keep families together, they all oppose the legislation. Please admit that that's funny.
It's not funny. Alondra Gonzalez, Colorado Department of Corrections Director of Communications, stated in an email, "We appreciate the sponsors' attention to this issue and are continuing to work with them on the bill." She went on to say, "We are currently working with Representatives Bacon and English, as well as Senators Coleman and Exum on the issue."
I would say Exum, but you're close. The article points out it's commonly understood that visits buoy the spirits of those locked away and their loved ones on the outside. Research shows that inmates having access to prison visits reduce recidivism. Imagine that. The effect of visitation on reentry success. A meta-analysis published in 2016 edition of the Journal of Criminal Justice analyzed data collected from 16 other studies. It found that visitation had a 26% reduction on recidivism. Now, again, the people that profess to be such guardians of the purse, I would think that if I could cut my prison population by a fourth with lack of recidivism, I would think this would be very appealing as a conservative, even if I don't care about my other principle of family values and keeping families together. Wouldn't you?
It seems sort of a no-brainer, but I'm trying to find like a negative angle to that, but I don't see how we could get there. Kim Ray, co-facilitator of End Slavery Colorado, advocated for the passage of the new law and says she has loved ones behind bars who will benefit from it. Opposed to the bill are Republicans, including Representative Matt Soper, who sits on the House Judiciary Committee as the longest-serving Republican member. He said in an interview that he was quite concerned with the creation of a statutory right to a prison visit. He went on to say, "In the prison setting, we need the Department of Corrections to be able to keep a prison safe and secure. And sometimes that involves having to cancel visitation at a moment's notice." He said he tried to find a way around this opposition, but just couldn't. "I wanted to get a yes, but just couldn't quite get there because for me, we just really have to give DOC as much latitude as possible with them to run their prisons rather than the legislature to come waltzing in and mandate certain things." Now, I have a question for you. Isn't this, what the heck's the thing called? Isn't this a delegation thing? Isn't this where you're putting the administrator in charge, but they want the legislator to make the rules of what medicine that the VA could give? Isn't that this?
Well, kind of. So I can see your point.
This sounds like talking out of both sides of their mouths, that they want the legislative body to make the rules, and then when they've made it, they're saying, no, we need to let them make the rules.
That's kind of what's happening here. But I see Representative Soper's point. You don't want a legislative body that's only in session part of the year, even if it's Congress, if they're out of session a lot of time. You don't want them to try to micromanage the prison. But on the other hand, it is within the sound purview of the Colorado General Assembly to establish minimum standards. And that's what they've done here. They have said that you will not deny visitation arbitrarily, that everyone has the right to visitation, that if you can narrowly explain a reason, you can deny visitation, but just as carte blanche, you can't do that. So I think that's within their sound purview, but I understand where Representative Soper is coming from.
Yeah, I would think that the person on the ground, particularly like at the institution, and there's something going on, that they would be able to click a switch and allow visitation, turn it on or off based on the climate in the prison. Maybe they don't have enough staff to run visitation. But what do you think the impact of this will be overall?
Well, according to the article, the number of people impacted by the law, while unclear, could be in the thousands on the outside who may want to see their loved ones and now can expect to be allowed even if the inmate violated a rule. According to Prison Policy Initiative, Colorado's total incarcerated population was 32,495 in 2024. But now this includes both state and federal prisons, youth lockups, and psychiatric facilities. The state prison population last year was 17,689. Might as well say 18,000.
Did you say 32,000 people?
I did, but it includes federal prisons and all the other types of lockups. But 18,000 is a fair number. But I'm curious if this right actually applies to federal inmates. The article does not state that 3 years before, state prisons contained about 2,000 fewer people. In 2021, there was only 15,865, of which 92% were male. So it sounds like to me that Colorado's on a rapid increase in prison population, despite their liberal lefty leanings. It doesn't sound like they've done a whole lot to reduce their prison population.
I thought that federal prisons were run by the Bureau of Prisons, the Federal Bureau of Prisons, and they are a completely separate entity to what the state does.
Well, that's the question I'm posing. If it's a law of the state of Colorado, can they apply it to facilities that are operated by the federal government in Colorado? Or will this only apply to Colorado inmates? We've got the resident attorney here. Do you think that the federal government can tell Colorado to pound sand that they don't have to give visits? Chance, what do you think?
I think that's correct. I think they can.
So,
interesting. The article notes that the prison population does not track the state's demographics of 41% of inmates were white, although 65% of the population of Colorado is white, and 17% of the prison population is black, although 5% of the population of Colorado is black. That's a little bit of a disparity.
That tends to be the case across the country, and every time I've tried
definitely
to dialogue with people about that, they have a response. They say that blacks commit crime at a higher rate, and therefore, if you didn't prosecute them, that you'd essentially be giving them a license to carte blanche to be criminals. So they have an answer for that. I don't know if I can argue with that. I haven't done enough study on that, but I also know that people who have less resources financially tend not to do as well in the criminal justice system. And it could be that they commit crimes that are roughly equal rate, and that the people that are more affluent have better outcomes. That could be a possibility as well. Chance, what do you think?
I would tend to agree with that, actually.
So you got a much more diverse state in California than even Colorado is. So do you see that gross mismatch between the ratio of prisoners in the California Department of Corrections and Rehabilitation?
I would probably guess it's probably the same, very much. Maybe, I mean, a variance, of course, in percentages, but I would think it would be reflecting the same thing. Yeah.
So, well, they had put the other demographics of the smaller. I cut them out because they were so small. But the disparity between black and white is fairly substantial.
Totally with you. Are we done?
I think so. Except we're going to promote the conference, and we're always going to promote FYP's merchandise, and we're going to let people know that we probably won't be recording next week. I'm pretty sure you've got a conflict.
There's no doubt I have a conflict because I have dinner reservations Saturday night at a restaurant, and so that will not work unless you want me to record from the Korean restaurant, which I will do.
That'd be fun.
Well,
fun.
Gonna be eating some chicken bulgogi.
I'm looking at my calendar, and I have 11 p.m. Eastern time Friday night open, so we could record then.
Oh, geez. Well, that would be one for... No, I'm not doing that, man. No. All right. Well, please, as Larry said, head over to registrymatters.co, and you can find show notes, which will include a link to fypeducation.org/shop. You can find the merchandise that is going to be there at the conference, which you should also be at the conference, which is in Grand Rapids, Michigan. On the 25th? Is that when it is, Larry? Well, no, it's like the 27th, I guess.
We actually kick off on the 27th. We'll have a meet and greet Thursday, the 26th, starting around 6 p.m. And then the program itself will kick off on Friday morning, the 27th, and it'll end Sunday around noon on the 29th.
Fantastic. And we will do a live recording, which all of them are live. It's not like we're recording dead, but we're going to do it with an actual studio audience. We'll find some place to set up shop. I've got this cool little gadget, Larry, that I'm going to hook up to my phone. I'm going to try and record it. For those of you looking at it, I have two little lapel microphones. I've got this little gizmo to attach to my phone, and we're going to be fancy with two little microphones that connect to your shirt. Again, looking up at the screen, you can see got a little doodad here. So hopefully we can record like that. I hope. It'll make my life easy.
That way, if I bang the table, it won't pick up on the microphone.
It'll probably still pick it up. But we'll give it a shot. Email registrymatterscast@gmail.com. Leave old-fashioned voicemail. at 747-227-4477, after which I will apply like technology to it to make it sound like you're talking on a tin can from the 1920s or something like that. And of course, I thank all of the patrons so very much. All the people here listening tonight live are patrons, and I love all y'all so very much. And that's over at patreon.com/registry matters. And that's all I got, gentlemen. Chance, thank you for joining us. Larry, as always,
My pleasure.
I appreciate it. Have a great night.
Thanks.
Thank you.
Good night.
You've been listening to FYP.